Okay. Counsel to the defendant, enter your appearance.
From respect to this honorable court, may it please your lordship. Counsel announce appearance for the defendant, Zell PLC. My name is Awujoola Adedamola, the lead counsel for this case, and here with me are Adepetu PM and Egunjobi PO.
Please spell
My
your
lord.
Awujoola. Spell your...
AWU.
Yes.
JOOLA. Should I go on?
Yes, go on.
Adepetu PM shall argue on issue 4. Myself will argue on issue 5, and Counsel Egunjobi PO shall argue on issue 6. Thank you, your lordship.
The second,
I didn't get that too.
come again. Counsel to the defendant.
Please.
Egunjobi PO.
Spell the
Egunjobi
Spell
EGUNJOBI.
That one is handling issue what?
5. Counsel Adepetu is handling issue 4.
Is that all?
Yes, my lord.
Okay.
My lord.
Like I said, yes.
Yes, my lord. Is Chima P, counsel for the plaintiff. Oh, there are some preliminary notices we'd like to bring to the notice of this court before we proceed. Is as regards the defendant's bill.
Okay, go on.
Yes, my lord. It's a tried principle of law and even of motive that when a statement of fact is given, all parties are to be bound by that statement of fact. But if you take a look at issue 5 of the defendant's bill, that's paragraph 5.6, there the imported facts talking about the inspection of the building, we are simply telling this court to discontinue such argument that was provided in paragraph 5.6 of issue 5 of the defendant's bill. This court cannot rely on it because it was not contained a statement of facts which binds both parties to this proceeding.
Okay.
Thank you, my lord.
Paragraph what?
Paragraph 5.6. Paragraph 5.6 of issue 5. They stated that Benz PLC having inspected the building before execution. My lord, there was nowhere in the statement of fact where it was stated that the building was inspected. Nothing as to that was provided in the statement of fact, and we are bound by statement of fact, which is like pleadings that parties are bound to. Because parties to a case, they are bound by their pleadings, and the statement of fact here is like a conjunction of the two pleadings from both parties.
Counsel to the defendant, respond.
My lord. Paragraph 5.6 of the defendant's movie clearly shows that before the execution of the contract, there must have been an inspection of the building. The plaintiff counsel cannot tell us that they didn't have an inspection of the building before they executed the contract. So, my lord, I would like to say that the inspection, the statement.
You are importing facts. Present.
My lord.
That's what you're imported.
We're not
present.
We did not import facts. We're just making a reference, my lord. It is just a statement, just an explanation.
Amoo, can you hear me?
I can.
Okay, do you have something to say to that?
No,
before we continue. Okay, I would rule on that by the end of the proceedings.
As the court pleases.
Okay.
Yes, my lord.
Registrar, I want you to read out the statement of fact. Registrar, are you there? Registrar. I think our network is not so good.
My lord, may the plaintiff counsel oblige the court of reading the statement of fact?
Okay, yes, go on.
Please. The case of Zenza PLC versus Benz PLC. The scenarios, paragraph 1. The scenario set hereunder shall be deemed to have occurred in the Federal Republic of Nigeria. Paragraph 2. Zenza PLC is a bank licensed to operate under the relevant governing laws. Zenza has been in operation since 1998 and its head office in Benin City, Edo State. The bank has been managed by 24 general managers and it currently has a total of 102 staff cut across the Federation. Paragraph 3. Benz is a bank licensed to operate under the relevant governing laws as well. Benz PLC has been in operation since 2008 with its head office in Ekoma, Edo State. The bank has been managed by 2 general managers and it currently has a total of 100 staff cut across the Federation. Paragraph 4. Bunji House is a building company owned by Federal Government of Nigeria, but currently being managed by Zenza PLC. An advert was placed in several newspapers by Zenza PLC as regards the letting of Bunji House. The advert contained, inter alia, well-secured storehouse. Paragraph 5. Benz PLC saw the advert and entered into an agreement on the 2nd of February 2020 with Zenza PLC for the rent of Bunji House. A documentary agreement was signed between both parties and it contained, inter alia, this is to satisfy the receipt of 100 million naira for the letting of Bunji House for 2 years. The contract shall linger for another 2 terms with the payment of additional sums of 100 million naira before the entire agreement can be terminated. If there be any dispute that shall arise out of this contract, both parties shall submit to the arbitration panel that shall be set up by Zenza PLC, and its decision shall be final. However, both parties make this contract having the hope that no quarrel shall arise from this agreement. Both parties shall keep this agreement and everything contained herein shall form the sole agreement to govern this contract. Paragraph 6. The document contained no term in relation to the provision of security. Benz PLC was to carry out the business of banking in the said apartment, particularly for the storage of important banking pieces. After the signing of the agreement, 2 weeks later, Benz PLC informed Zenza PLC that it will be packing into the apartment soon, that everything should be put in place, but the apartment is already being used for the keeping of banking records. Paragraph 7. 2 weeks passed. Benz wrote a letter to Zenza PLC demanding that the building be renovated and the ceiling repaired before it packs in fully, and that it is an implied term for the building to be in order before Benz PLC can carry on its business in the Bunji House. Zenza PLC replied that the terms of the contract are clear as to what each party's duties are, and that it is not responsible for innovating or affixing any repairs to the building, and that Benz PLC should be the one to renovate the building since the building has been let to it. Paragraph 8. On the 23rd of March 2020, the NBA House, Edo chapter, was razed down by thunderstorm. All receipts and documents kept in it were lost. The NBA, Edo chapter, released a circular to the effect that all lawyers should be on hold and go on, and that the issuing of certificate for the year will commence soon. Aki SAL, counsellor representing the plaintiff, has not paid his practicing fee for the year due to the raise on the NBA House, Edo chapter. Paragraph 10. On the 1st of April 2020, Benz PLC visited the Bunji House and found out that its banking records kept in the storehouse have been boggled. Paragraph 11. Benz PLC instituted an action in court and on the 9th of April 2020 has completed all the processes for the matter to be heard at the Federal High Court. Paragraph 12. The Attorney General of the Federation has applied to be joined as a proper and necessary party to the suit. Paragraph 13. Preliminary objections have been raised by the defendant. The defendant, Zenza PLC, is further alleging that they cannot be sued because they are acting in the capacity of an agent for the federal government. My Lord, this is the fact that have been settled before this honorable court.
Okay, thank you very much.
As the court pleases, my Lord.
Yes. Okay, we'll be using the grading system as we used the last time. We grade you on your advocacy skills, understanding of facts, the application of law to fact, time management and brief. Your individual brief, not your entire brief, on each issue that was raised. That's what we'll be grading you on. So, counsel to the plaintiff.
Yes, my lord. At this point in time, I'm the counsel taking the first, which is issue 4. I still leave of this court to enter into appearance.
Go on.
As the court pleases. My lord, may it please this honorable court, entering appearance is Chima P, counsel for the plaintiff, representing 200 level faculty of law, University of Benin. My lord, I shall be arguing on issue 4, and issue 4 states whether EKSU can represent the plaintiff in this suit. My lord, this particular issue was raised as a preliminary objection which the defendant filed when this matter was brought before this honorable court, and they are saying that EKSU, due to the fact that his legal practitioner annual practicing fee, he cannot represent the plaintiff. But now, looking at this issue from the surface, we might say that the defendant is right. However, we are calling on this court to take a very deep look of the particular circumstances that have been submitted for it to determine. And as we heard in several cases, the Supreme Court and Court of Appeal, that every case that comes before a court of law is unique. And it's from that particular case that the court is to give judgment. And we are submitted on this ambit that since this particular case has come before this honorable court is unique, I would are going to show as my argument continues, we are saying that this court should look at the particular circumstance, the peculiar circumstance of this case, and judge this issue and allow EKSU to represent the plaintiff. My lord, the several laws that govern the local profession in regards to the payment of annual fee includes the Rules of Professional Conduct 2007, the Legal Practitioners Act, LPA 2004, and the Nigerian Bar Association Constitution 2015. My lord, the provisions for these particular laws were duly provided in the plaintiff's brief in regards to issue 4, so I shall not spend precious time to read out the particular provisions. The import of these provisions are that a legal practitioner is to pay before 31st of every year his legal practitioner fee. It is annual and it is compulsory. And any practitioner that does not pay will be liable to
31st of what?
31st of March every year. My lord. As the court pleases. My lord, and any legal practitioner that does not pay this particular fee will be held to have conducted himself in a way that is not proper. But now we should take a cursory look at a statement of facts. The statement of facts in paragraph 8 told us that the MBA house Benin chapter was raised down by a thunderstorm. And it went ahead to state that documents and receipts kept in this house were destroyed. And after this, the MBA house released a circular to the effect that all lawyers should be on hold. Now, this is provided in the statement of fact, paragraph 8, that all lawyers should be on hold. And the issue of certificate will commence soon. But the certificates are given when the practitioner has paid his annual fee. If the practitioner has not paid his annual fee, there's no way certificate is given to him. By this import, what the MBA house is saying by the circular is that because of the raise, no certificate is given yet, but rather all lawyers should be on hold. And when certificate is about to be given to every practitioner on the payment of their annual fee, then they will release a circular as to that effect. Now, paragraph 9 told us that EKSU, my lord. Yes, my lord.
What do you understand by the simple statement, all lawyers should be on hold and go on? I need to explain that statement to me in 1 minute. All lawyers should be on hold and go on.
Yes, my lord. Thank you very much for that question. My lord, taking a very good look at the statement of facts and words and sentences have to be interpreted from the context in which they appear, it is obvious that what they mean by this is that all lawyers should not pay their annual partnership fee yet until a notice has been given. In fact, they went there to state that the issue of certificate will begin soon. This is to signify the fact that they are not issuing certificate at the particular point and that lawyers should be on hold. My Lord, and we want this court to also take notice of the fact that it's the same MBA house who made the rule. The same MBA that made the rule that lawyers have to pay their practitioner fee before the 1st of March is the same body that's now saying that lawyers should be on hold. Lord, that is what I understand by, that's what the fact is telling us by that clause that all lawyers should be on hold and the issue of certificate will begin soon.
So are you saying that that statement means that though they've not paid their practicing fee, they can as well do other activities as a lawyer?
Yes, my Lord. That's what that particular phrase is telling us.
Okay. Go on.
Yes. As the court pleases. So the statement to fact told us further that EKSU has not paid the legal practitioner fee due to the raise that happened. Due to the raise that clamped down the MBA house. It went there to give us a reason. It said it is due. It is due to this raise. This was provided in paragraph 9 of the statement of fact. But it is obvious that EKSU has not paid because of the circular that was given by the MBA house. After the house was clamped down by the thunderstorm. And further, my Lord, it will be ridiculous for any counsel to come to this court to argue that a man like Aki, who is a senior advocate of Nigeria, would be undiligent in not paying his practitioner fee. But he has been paying his practitioner fee for not less than 10 years, because before a legal practitioner can be a senior advocate of Nigeria, he must have gained distinction in the legal profession for not less than 10 years. And EKSU, according to the fact, is a senior advocate of Nigeria. There is no way that we can say at this particular point, Aki does not want to pay his practitioner fee. It is obvious that he's simply obeying the circular that was released by the MBA house.
Are you trying to say that because he's... Counsel,
yes,
hold
my
on.
Lord.
So are you trying to say that because he's a senior advocate, we should relieve him of his responsibility and duty under the Legal Practitioner Act to pay his practicing fees?
No, my Lord. Counsel is simply stating that EKSU at this particular point will not be this undiligent not to pay his practitioner fee because this is something he has been paying. And we are saying that he's simply obeying the circular that was released by the MBA house. That is all. My Lord, even if he insisted that he wanted to pay, he cannot pay because the MBA house, they won't listen to him. They released the circular. They said that all lawyers should be on hold. That's what the circular states, and that's what he's obeying. Simple.
Okay.
Are you done?
Yes, my Lord. My Lord. No, I'm not done, my Lord. My Lord, further, counsel is also something before this honorable court that it will be tantamount to technicalities. If this court, having taken a look at the peculiar facts presented by this case, should rule that EKSU cannot represent the plaintiff, it will be nothing but technicalities. And technicalities have been overruled and have been casted upon by several decisions from the Supreme Court and Court of Appeal. My Lord, we did very well to provide some of the cases where technicalities have been clamped down in the defendant's brief in regards to before. And hence, I'm submitting finally, and I'm praying to this honorable court that this court should allow EKSU to represent the plaintiff as he judge this issue in favor of the plaintiff.
Counsel, can you hear me?
Yes, my Lord.
Okay, I have a question. Since EKSU did not have a right to appear before a court, according to the Legal Practitioners Act, why did the plaintiff in this case not employ another counsel?
My Lord, as regards why I didn't employ another counsel, we are not told that in the statement of fact. So I don't think I can actually say anything reasonable that. If I say anything, I'll be importing facts into the statement of fact. I'm bound by it. And I'm only to talk about why EKSU can represent the plaintiff in this particular suit.
Okay, so I'm going to rephrase my question. So, since EKSU is not political, do you agree with me that it's only right that another counsel is employed to represent?
My Lord, yes, another counsel can represent the plaintiff. However, that does not stop EKSU from the peculiar facts presented from representing the plaintiff.
But you are telling the court focus on justice, it should not focus on technicalities and all. But since another counsel can represent you, the plaintiff, in this particular case, therefore there's no need for EKSU to be here then, don't it?
My Lord, I believe that the plaintiff, which is the Benz Bank, have chosen Aki SAN. And my Lord, it is a very important factor that Section 36 of the Constitution, no, Section 36 and Section 35 gives every party the right to a counsel. My Lord, the right to a counsel is something that every party must have.
I know. Counsel, listen to me. I know Benz Bank feels they have the right to. You only have the right to a counsel who has paid his legal practitioners and who is licensed to come before the court to appear. And Aki SAN is not giving that permission in this particular case. So why not go for another counsel who is qualified? Don't you agree with me?
My Lord, I agree with you to the extent that that counsel can actually represent the plaintiff. But I also agree.
Since you agree with me, then it's okay for us to say that Aki SAN cannot appear before us because he doesn't have the right, doesn't have standing. Don't you agree with what I'm saying on that?
No, my Lord, I do not agree that Aki SAN cannot represent the plaintiff. I strongly believe that from the peculiar situation presented by this case.
You just agree with me right now. I'm listening.
My Lord, I stated that another counsel could represent the plaintiff, but Aki SAN is not bad for representing the plaintiff also. And the Benz Bank has chosen him because they are exercising their constitutional right, my Lord. And the peculiar circumstance of this particular case is very unique. And looking at the circular that was released to by the MBA House, my Lord, we are simply begging and pleading before this court that they should take cognizance of this. Technicality should not override justice.
But you keep saying technicality should not override justice. I feel technicalities will override justice in a case where this situation affects all lawyers in the federation, not just some lawyers in the branch, not even all lawyers in the branch. So, if another counsel can represent your client in this case, don't you think that counsel should be able to represent your client and not Aki SAN? And we should not allow Aki SAN be given that right because the rules of professional conduct and the Legal Practitioners Act stops him, bars him from representing your client. Don't you think?
No, my Lord, no. Yes, my Lord, I heard your question very well, and I'm going to reply to it. My Lord, the circular that was released is actually has an effect on all legal practitioners because it didn't mention legal practitioners as going to have an effect on.
You read the circular.
Okay, my Lord, I will read it.
Okay.
Now, the circular states that the NBA Edo chapter released a circular to the effect that all lawyers should be on hold and go on, and that the issue of certificate for the year will commence soon. My Lord, that was the circular.
Okay, so the NBA Edo chapter will release a circular that is binding all lawyers in. Is that what? Yes.
Yes, my Lord. My Lord, the NBA Constitution gives them this right. The NBA Constitution 2015, by virtue of Section 13 sub 2, states that nothing in this Constitution shall debar all the branches in any state from holding joint meetings or consultations to discuss matters of common interest for the overall good.
I want you to look at it in the context of fact. So the documents that were burned, the documents that were destroyed, was it the document for all NBA members for the whole federation or for those in Edo State?
My Lord, I will not be able to answer that question because statement of fact never provided that effect. If I should say anything, I will be importing to the fact, my Lord.
Okay. So if the NBA chairman is coming, NBA Edo chapter is coming out to release a circular in Edo chapter and saying that because of this thunderstorm, the NBA out in Edo chapter was raised down, just Edo chapter, and he's saying because of this, all lawyers should be on hold and go on. Don't think that the lawyers is referring to in that particular scenario is those in Edo chapter. Are you saying that he's referring to all lawyers in the federation from Enugu to Lagos to Kaduna? Is that what you are saying here?
My Lord, on this particular question, I agree with you that it's referring to lawyers in Edo State who are affected by this particular branch.
Okay.
Yes, my Lord.
definitely you are agreeing with me then that RTSN cannot represent your plaintiff.
No, my lord, I'm not agreeing on that particular point. That particular point that I cannot represent the plaintiff, I'm not agreeing on that. I still asserting the fact that he can represent the plaintiff very well. Because he's bound by his branch, and his branch has released a circular, and he's ought to obey that circular that was released by his branch, my lord. So even if he insisted that he wanted to pay his legal practitioner's fee, he was bad, he could not pay, even if he wanted to pay, my lord.
Then definitely those that have paid their legal practitioner fee have the right to appear before the court should be employed. That is what I'm trying to say. And counsel, you have been agreeing with me so far. You definitely see what I'm saying. So you cannot come to the court and talk about technicalities when there are numerous lawyers out there who have paid their legal practitioner fee, who are well viable to represent your client in this case, who should have come before us, not at TSA, and not because he's a senior advocate of Nigeria with over 12 years of paying. We don't care about that. Have you paid your legal practitioner fee? It's what it's asked. And he hasn't paid it, therefore he shouldn't represent. Simple. No further.
As the court pleases.
Next.
Counsel.
Yes, my lord.
Yes, back to the circular.
Yes, my
I
lord.
want to read the first line of the circular from the NBA Edo chapter.
Yes, my lord. I should read it, ma'am.
Read from your brief, paragraph 8.
That's the statement of that. Yes, the statement of fact.
No, your own brief, paragraph 8.
Okay, my lord. Paragraph 8. My lord, I do not have paragraph 8. Mine stopped at paragraph 7.
No. There's a word that begins paragraph 4.
Okay, paragraph 4. The facts present. Okay, yes, my lord.
No, you're starting paragraph 4. Start from paragraph.
Paragraph.
The facts presented before this court is sui generis and has never been determined before any court of law. Now, looking at the statement of fact, paragraph 8, which is the relevant fact as regards this issue, states, on the 23rd of March 2020, the NBA House, Edo chapter, was razed down by a thunderstorm.
It's okay. Now, you said on the 23rd of March,
yes, my lord,
the NBA Edo chapter was raised on fire.
Yes, my lord.
When is the deadline for payment of practicing fee?
31st of March.
So do you want the court to believe that your so-called diligent son, Akin San, could not pay his practicing fee from the 1st of January to 23rd of March and decided to come to this court and file an action where he's supposed to have paid his practicing fee?
My lord, between 23rd and 31st is quite an ample of time for him to pay. And
how many days?
My lord, 23, 24, 25, 26, 27, 28, 29, 30, and 31. My lord, that's 9 days. 9 days is enough for him to pay.
Hold on, counsel. I'm relying on your statement where you called Akin San a diligent counsel. That's what I'm relying on. So you don't you don't expect this court to make a precedent that puts sons and other senior counsels in the pedestal of technicalities and injustice when it comes to payment of practice fee, which is a responsibility and a duty under the Legal Practitioner Act, which governs all lawyers in Nigeria.
Yes, my lord. The reason I stated he is diligent is because he cannot even be an senior advocate of Nigeria if he was not a distinct man and a diligent man, because it's only such person that can become a senior advocate. That's why I said he's a diligent man and he's very distinct.
So his diligence does not extend to his due payment of his practicing fee?
My lord, it extends, but the Act did not tell us that persons who pay between this time are diligent, or persons who pay between this time are diligent. It simply states that the deadline is state-faced. So anybody can pay. You can even pay on the 29th. That doesn't affect the fact that he's a diligent man.
So you can agree with me that the suit which he filed this suit in February. Am I correct? He filed this suit in February 2020.
My lord, 2020. No, my lord.
When? What date? What day was this suit?
The Ben's PLC instated an action in court on the 9th of April 2020, my lord.
Okay,
9th of April. That was after
2020.
Yes.
2020.
Yes, my lord.
Okay, so he didn't pay his party fee till March 23rd, and then up till April before the suit was filed. I'm trying to understand where his diligence is coming from. You cannot listen to me, counsel.
Yes,
you cannot, if you read the Legal Practitioners Act, Rules of Professional Conduct, it specifies in Section 9, subsection 3, that a lawyer shall not sign documents, meaning he has signed documents from January till March 23rd, without paying his practicing fee. He has filed pleadings without paying his practicing fee, and he expects this court to grant him the leave relying on the so-called thunderstorm bonds on the NBA Edo chapter.
My lord, he was simply obeying the circular. He is bound to obey the circular that was released.
I believe I've gotten what I wanted. Thank you very much. That'll be
all. As the court pleases, my lord. As the court pleases.
Yes. Counsel on issue 5.
May it please this court, entry into appearance is Ikeriehi P, co-counsel to the plaintiff. Your Lordships, representing the University of Benin. Your Lordships, I'll be addressing issue 5 as to whether or not Zenze PLC is obligated to renovate the apartment before Ben's PLC occupies it, and counsel humbly submits in the affirmative. It's at this point that counsel seeks the leave of this honorable court to delve into the substantive aspect of our argument.
Counsel, hold on. You can go on.
It's at this point that counsel seeks the leave of this court to delve into the substantive aspect of our argument. Your Lordships, it is quite evident that what is in contention before this honorable court is whether or not there is an implied term for Zenze PLC to renovate the apartment before Ben's PLC occupies it. Your Lordships, this then brings the burning question to light. What is an implied term? Put simply, Your Lordships, implied terms are terms that the court would assume are intended in a contract, even though they are not expressly stated. Your Lordships, in the case of Multi-Choice Nigeria Limited and Aziz, citation duly supplied in counsel's written memorial, the court by allowed Go JCA stated as in implying terms in fact, the exercise involved is that of ascertaining the presumed intention of the parties, collected from the words of the agreement and also surrounding circumstances. Your Lordships, moving further, also in the case of registered trustees of Masters Vessel Ministries Incorporated and MNEK, the court by Ogunwumi JCA stated that a lessee has a right to quiet and peaceable enjoyment of land and fitness of premises, Your Lordship, and fitness of premises for habitation. Your Lordship, adopting the words of Peter Odili in the case of Union Bank and Oma Properties Limited, where he expressly said that it needs not be stated that one cannot escape liability merely or simply because certain terms are not engraved on stone, when the words of the agreement and surrounding circumstances, Your Lordships, shows what parties intended. Your Lordships, having lucidly elucidated how courts construe implied terms, let us now critically examine the statement of fact to determine the surrounding circumstances and what the parties really intended. Your Lordships, a critical analysis of paragraph 4, lines 2 to 4 of the statement of fact states, and I take leave of the court to read.
Yes, go on.
It states, your lordships, that an advert was placed in several newspapers by Zenze PLC as regards the letting of Ungi House. The advert contained a well-secured storehouse. Your lordships, for emphasis, a well-secured storehouse. Your lordships, it can be evinced from the statement of fact that the presumed intention of Zenze PLC, that Zenze PLC had the intention to sell a well-secured storehouse, and my client also intended to purchase a well-secured storehouse. Your lordships, let us now demystify what a well-secured storehouse would mean. According to Merriam-Webster's dictionary, the term secured means free from danger, free from risk of loss, or free from exposure to danger. Your lordships, flowing from the definition that was given by Merriam-Webster's dictionary and applying it to the instant case, it simply means that the storehouse in question would not just be free from danger or loss, but completely and entirely free from any risk or exposure to danger. Because in this instance, your lordships, we are not just dealing with a secure storehouse, but a well-secured storehouse. Your lordships, you would agree with me, and my opposing counsel would also agree with me, except the truth wants to be concealed, that we need no soothsayers to tell us that a dilapidated building that comprises a faulty ceiling is not well secured. Your lordships, let's even be very feasible and practical. This is a storehouse that is intended to be used for banking purposes, to keep important banking pieces, of which Zenze PLC is fully aware of. Your lordships, a building with a faulty ceiling cannot be well secured. Your lordship, it is not alien to this honorable court that we are in Nigeria and humans love anything that has to do with money. Anyone that has ulterior motive can jump through the ceiling and steal whatever it is that is kept in the storehouse. Your lordship, how then is this warehouse secured? Not to talk of well secured. Your lordship, looking at it from another angle, a faulty ceiling can expose whatever it is that is to be kept in the storehouse to danger. Your lordship, it is quite evident that since the representation of a well-secured storehouse was put forth, and that wasn't what was given, my client simply requests that they live up to their own end of the agreement and repair the storehouse to conform to the representation made. Your lordship, furthermore, opposing counsel may want to state that a person who signs a contractual agreement is bound by such terms. Your lordship, counsel wants to state emphatically before this honorable court that is not contention. Yes, a person is bound by the terms of a contract, but let us take our minds back to the words of Mary Peter Odili in the case of Union Bank and Oma Properties Limited, where she stated that a person cannot escape liability merely or simply because certain. Let me break it down a bit. What she simply meant was that a person is bound by the contractual terms of an agreement, but such a person cannot escape liability where liability is due, merely or simply because such terms are not written down. Your lordship, so that opposing counsel doesn't lead this honorable court to indiscretion, I will stand on the Latin maxim. I will stand on the premise of the Latin maxim, which states "facti cesare tacitum," which is to the extent that what is expressed makes what is implied silent. Your lordship, assuming but not conceding that the express statement of the agreement contained or stated that Zenze PLC would not be liable for any repair of any sort, despite the representation of a well-secured storehouse given, then my agreement will crumble like the walls of Jericho. Your lordship, but this is not the case. They simply represented that they had a well-secured storehouse to sell, and that's all. There is nothing in the agreement that excludes the liability of what they ought to do. And since this is not the case, your lordship, then they cannot cry foul and they cannot escape liability. Your lordship, it is on this premise that counsel humbly submits that Zenze PLC is obligated to renovate and repair the storehouse to ensure that they keep to their end of the agreement. Your lordship, counsel humbly prays that this court grants judgment in favor of the plaintiff and ensure that justice serves by enforcing the full terms of the contract, both implied and explicit in their totality.
Amoo,
Yes, sir.
any question for?
Yes, but
I can't hear you, your lordship.
I said I need a minute. I'm coming.
Okay.
There's a case you cited.
Yes, your lordship.
The last case you cited? It's not on your brief.
Union Bank and Oma Properties Limited.
Is it on your brief? Okay, I found it.
Yes, it is. Yes, Your Lordships.
Okay, Counsel. Can you hear me?
Yes, Your Lordships.
I'm saying you waited for your properties destroyed before you approached the court. That's the only thing I'm trying to.
That I waited for the properties to be destroyed.
Yes, because I see that 2 weeks after you signed the document, requested Zenze PLC to repair your building and everything according to implied terms of the contract, right?
Yes, Your Lordships.
So when Zenze PLC did not repair that building, why didn't you approach the court?
Your Lordships, my counsel, it was simply waiting, Your Lordships, or probably if Zenze PLC
waiting for your properties to destroy.
No, Your Lordships. We're waiting for them to simply do what they ought to do, Your Lordships, before we approach the court.
But they replied you stating that you are the one to repair it.
Yes, Your Lordships.
So why didn't you approach the court at that point in time before allowing all this to happen? Or you were waiting for your properties to destroy so that you could come to the court and say, oh, they breached the agreement, we want to go back on the agreement, we want damage.
No, Your Lordships, there's no way even in the statement of fact that expressly states that our properties were destroyed, Your Lordships.
Okay, so I'm saying, why didn't you approach the court at that time when Zenze PLC stated that your responsibility to innovate the building? So, bottom line of my question is, why didn't you approach court when Zenze PLC replied you that it is your responsibility to accept that responsibility at that point?
Your Lordships, we're still thinking that they will do what they ought to do, Your Lordships, despite the reply. That was representation given.
What they promised to do, or you were waiting for your properties to get destroyed for you.
Your Lordships, there's no way in the statement of facts that everyone expressly states that our properties were destroyed, Your Lordships. So we're simply waiting for them to do what they ought to do.
Okay, counsel. Can you hear me?
Yes, I can hear you, Your Lordship.
Did you move into the building before signing the contract?
No, Your Lordships.
Go to lines, paragraph 6 of the statement of fact.
Yes, Your Lordships.
Read that paragraph.
The document contained no term in relation to the provision of security. Ben's PLC was to carry out the business of banking in the said apartment, particularly for the storage of important banking pieces. After the signing of the agreement 2 weeks later, Ben's PLC informed Zenze PLC that it will be packing into the apartment soon, Your Lordship, soon, that everything should be put in place, but the apartment is already being used for keeping of banking records. Your Lordship, Ben's PLC emphasis on line.
Hold on, I've not asked you any question.
Yes,
Counsel, I've not asked you any question.
Okay,
I just said read.
Okay, Your Lordship.
When you read, you listen.
Okay, Your Lordship.
Yes. So did you ever visit that warehouse before signing the contract?
Your Lordship, the warehouse was not visited. No, Your Lordships.
Okay, that'll be all for you.
Thank you, Your Lordship.
Counsel for issue.
May it please this court. I am Rhoda Iyasele, counsel for the plaintiff, representing University of Benin. Your Lordships, I will be handling issue 6, which states whether Zenze PLC is liable under payment, and to this, counsel submits in the affirmative. It's at this point in time that counsel seeks the leave of the court to move on with the substance of our argument. It is pertinent at this time to define the word payment, which forms the crux of my argument. Your Lordship, payment has been defined in the case of Wema Bank PLC and Osilaru
Citation also duly supplied in counsel's written memorial. Per Awala JCA defined payment, and I seek the leave of the court to read.
Go on.
A payment is the transfer of possession of goods to a bailee, not the ownership by the bailor. Lordship, for further clarity and brevity, and not to waste the time of the Honorable Court, I will be dividing my argument into two main standpoints. One is the essential characteristics that must be in place before the thought of payment can arise. Your Lordship, there must be a contract between the party who delivers the goods, that is the bailor, and the party which receives the goods, that is the bailee. No matter if it is implied or expressed. Your Lordship, has also been established in the case of UniBen PLC and Awujoola, citation duly supplied in counsel's written memorial. It stated the fact that it is elementary law that a contract may be demonstrated by the conduct of the parties as well as the deed or the document that has passed between them. Lordship, there must be change in possession. The possession and custody of goods change and not ownership. The change in possession took place can either take place either by actual delivery or by an act. Lordship, moving on to the second standpoint, the duties and liabilities of a bailor. One, it is the duty of the bailor to disclose any fault. Lordship, if the bailor fails to do so, then he will be responsible for the damage caused to goods or loss suffered by the bailee. Two, the bailor is under the duty to pay the extraordinary expenses incurred by the bailee for such payment. See, it is the duty of the bailor to indemnify the bailee for the costs incurred due to the defective title of goods paid to the bailee. Lordship, it's an application of the affirmation rule of law to the issue at hand. It can be seen on the first standpoint of my argument, which is the essential characteristics that must be in place before the thought of payment can arise. Lordship, it can be seen from paragraph 5 lines 1 to 6 of the statement of fact, which is our guide in this matter, and I seek the leave of the court to read.
Okay,
Your Lordship. Okay. Your Lordship, on the first standpoint of my argument, which is the essential characteristics that must be in place before the thought of payment can arise. One, it can be seen from paragraph 5 lines 1 to 6, and it says, and I see the leave of the court to read. Ben's PLC saw the advert and entered into an agreement on the 2nd of February 2020 with ZZ PLC for the rent of Bungee House. A documentary agreement was signed between both parties, and the content thus: this is to certify the receipt of 100 million naira for the letting of Bungee House for 2 years. The contract shall linger for another 2 terms before, with the additional sum of 100 million naira before the agreement can be fully terminated. This paragraph clearly shows a valid contract between both parties, as also seen in the case of UniBen PLC and Awujoola. In this case, the bailor, the defendant, ZZ PLC, and my client, the bailee, the goods in question were kept in Bungee House, which comprises of a warehouse. There was a change of possession and custody of the warehouse, Bungee House, after the payment of the fixed price of 100 million naira. Ben's PLC stated that they will be using Bungee House for the storage of important bank pieces, as seen in paragraph 6 lines 1 to 3 on statement of fact. Moving on to the second standpoint of my argument, which is the duties and liabilities of a bailor. One, ZZ PLC owed my client a duty to disclose any fault in Bungee House. They failed to do so, even when my client wrote to them to inform them about the dilapidated condition of Bungee House, as seen in paragraph 7 lines 1 to 2 of the statement of fact, and it says, and I take the leave of the court to read. 2 weeks passed, Ben's PLC wrote to ZZ PLC demanding that the building be renovated and But your lordship, they bluntly refuse when it's obviously their duty. 2, the PLC has a duty to pay for the renovation of Bungee House, which they also bluntly refused, and to give us the cost, which was incurred by my client as to the defectiveness of the apartment. Lordship, it is quite clear that the defendants were never straightforward in this contract in the first place and should be made to face the consequences of their actions. Counsel hereby submits that this PLC is liable in payment and the cost of 200 million naira be awarded against them as the general damages. And I pray this honorable court upholds justice by resolving this issue in favor of the plaintiff. Lordship, it's at this point in time that counsel rests the case. Your Lordship?
Yeah, so you are stating that the contract between your client and the defendant is that of payment and not of rent or any type of contract. Is that what you're stating?
Yes, Your Lordship. Yes, Your Lordship.
Okay. Amoo, do you have any question for her?
I want you to give me a case and the facts of the case on bailment. Because I think I'm only seeing one case in your brief here. Just cases now.
Okay, Your Lordship, I will do that.
Are you trying to open your...
No. Your Lordship, in the case of Aviation Handling Company Limited and Yinka World Investments,
Okay.
the court held that
The fact of it, not just because of it, I need to know that you understand what you are talking about. Because I can barely see any in your brief. Just 2.
well, why that happened was because of so that the counsel's brief will not be too bogus.
But you don't need to bother yourself with that. That's not for you to bother. You have to bring a detailed brief before your lordship. So whether it's bogus or it's not for you to decide that way. So don't forget to give me case in fact I asked for the counsel. Are you there?
Yes, Your Lordship.
So where is it?
Well, in that case, the court held the
Which case?
fact was that the defendant had like a goods were
So it's like you just keep stammering. It's like you're not aware of the fact of it, or maybe you are trying to put somewhere, or I don't understand. What is going on? So in your preparation for your matter on bailment, you did not read one full case with the fact and the court order, so you get a proper grasp of what you are talking about.
no.
That's what you are telling them. Because you just came with 2 court things, and I think there's a particular case kept using. I think it's a case of UBN and OCJ. I kept hearing it, and I think I didn't hear any other case. So give me another case that further explains bailment with the fact.
I mentioned the case of Wema Bank PLC and Scenario.
Okay,
That was
it's
given
like
in my
you don't
introduction
have any
to define the
understanding.
meaning of the word payment.
Okay, that's very fine. You can proceed, Your Lordship.
Okay. Counsel to the defendant. May I announce your appearance? Registrar, please look for the counsel to the defendant.
Entering appearances Adepetu PM.
Okay.
and I shall argue on issue 4 as to whether Aki's SAN can represent the plaintiff in this suit. Your Honor, the defense answers this question in negation, relying on the provisions of Rule 9 sub 3 of the Rules of Professional Conduct for Legal Practitioners 2007. This has been provided in the defendant's brief of argument. In this provision disallows a legal practitioner who is in default of the payment of his annual practice fee, no matter the reason, from appearing before the court of law or even act in capacity of a legal practitioner. This rule was also corroborated by the provisions of Section 3 sub 2 AII of the Nigerian Bar Association Constitution. Any member who fails or neglects to pay the prescribed annual practicing fee before the end of March each year shall, as long as he or she remains in default, have no right A. of audience in court, B. to prepare, authenticate, or frank any document including memorandum and articles of the association, and C. a failure or neglect to pay the practicing fee as and when due shall be deemed to be an act of professional misconduct. I would love this court to take note of the word used in this constitution, a failure or neglect. The word failure seemed to me to be with a sign no matter the reason, that is, without subjection to whatever the reason for the failure might be. The counsel to the plaintiff was unable to prove his point. He was unable to state why the counsel acting SAN can represent the plaintiff even though he is in default of the payment of his annual practice fee. Nevertheless, I proceed. Your Honor, aside being called to bar, prompt payment of the annual practicing fee is what gives the legal practitioner the license to act as one. And it is imperative to note that any lawyer who defaults risks forfeiture of every right a legal practitioner enjoys in court or corporate practice, and loss of other rights and privileges generally. All these go to show the essence of the payment of the annual practicing fee in the noble profession. The Supreme Court held that the provision of the Legal Practitioners Act as statutory, and therefore of substantive law cannot be waived. The Supreme Court also, in the case of Ajakai versus Federal Republic of Nigeria, held that a person who is qualified as a legal practitioner within the meaning of the Legal Practitioners Act is entitled to appear and be accorded audience in any court of law throughout the country. However, one major exception to this right of audience, to the rule of right of audience, is clearly stated in Section 8 sub 2 of the Legal Practitioners Act, Chapter L11, Laws of the Federation, 2004, which expressly states that no legal practitioner shall be accorded the right of audience in any court in Nigeria in any year, unless he has paid to the registrar in respect of that year a practicing fee as time to time prescribed by the Attorney General of the Federation after consultation with the NBA. Your Honor, the plaintiff made the statement by the NBA in paragraph 8 of the Statement of Facts as an automatic exemption. However, this first is not sufficient to override the principle clearly stated in the Legal Practitioners Act. For Aki SAN to represent the plaintiff, then an express provision is required in the same statute. These provisions are statutory, and as a matter of fact, Your Honor, I cannot find any exceptions to the principle of rules, to the practicing rule, fees rules under. Excuse me, Your Honor, may I go over that? I cannot find any exception to the practicing fee rules within the four corners of this statute. To conclude, Your Honor, the raid of the NBA House Edo chapter by a thunderstorm is not an excusable proof sufficient enough to exempt a legal practitioner from the payment of the statutorily established annual practicing fee. Your Honor, this is because a similar occurrence happened sometime in 2015. The NBA, in a paid advertisement, informed its members that the payment of the annual bar practicing fee that started from January 1st, 2015 would end on March 31st, 2015. The advertisement went further to state that all legal practitioners enrolled at the Supreme Court of Nigeria whether public, private, or corporate practice, are required to pay on or before the end of March 31st, 2015 to the NBA accounts with Access Bank PLC. However, a large number of lawyers were unable to pay because the designated Access Bank unexpectedly shut its doors against its customers at 12 noon on March 31st, 2015, due to possible breakdown of law and order when the results of the March 28th presidential election were being announced by INEC. And many lawyers were unable to pay their practicing fee. And it would be of interest to this court that when the chairman spoke, Mr. Inka Farombi, the NBA chairman, Ikeja branch, he said that the payment of practicing fee is statutory, and the only option open to lawyers at that time were to make their payment online to the Supreme Court. Your Honor, no exemption was made for these lawyers at that time, and this is to show that the principle of law is straight and firmly established, and this profession is a noble one of distinctive and spectacular ethics. No form of indiscipline or anomaly can be tolerated, and if there is anyone who should know this, it is a senior advocate of Nigeria who has over 10 years of experience at the bar. Defense thereby humbly submits to this court that this court give no right of audience to Aki, senior advocate of Nigeria, as is unqualified to represent the plaintiff in this suit, is at default of the payment of his annual practicing fee and therefore cannot represent the plaintiff in this suit. We pray this court rule thereby and restore decorum and discipline to this honorable court. I rest my case, Your Honor.
Amoo.
I don't have any question.
Okay. Counsel, I want you to read the provision of section of Rule 9, Sub-Rule 3 of the Rules of Professional Conduct from your brief.
Yes,
That's paragraph 4.1 and 4.2.
I proceed. A lawyer shall not sign documents.
Go on.
It's like your network is breaking.
Yes. Adepetu. Okay. I think we'll come back to her. Counsel for issue 5. Are you there?
Yes, my lord.
Yes, go on.
May it please this honorable court. Entering appearance is Awujoola Adedamola, counsel for the defendant. I shall argue on the issue 5 as to whether the PLC is obligated to innovate their patent before Ben's PLC motion. My lord, on this issue, counsel has two major submissions. One, that the terms of the contract are binding on the parties to it, and hence any term not expressly agreed to cannot be read into it. And two, that the renovation of the building cannot be implied in the contract. Counsel seeks the leave of the court to proceed with the argument.
Go on.
My lord, on issue 1, a person who signs a contractual agreement is bound by the terms of the agreement. My lord, the building in question, Bongi building, comprises of a warehouse used only for storage purpose, and that was the essential purpose for which Ben's PLC negotiated and executed the contract, as it was stated in paragraph 4 and 5 of the statement of fact. Your lordships, and for the purpose of storing banking documents, the building was fit and proper. Your lordships, if a contract agreement is in its written form, like this present one, and someone signs it, then it is typically bound by the terms of the contract, regardless of whether they have actually read it, provided the document is contractual in nature. My lord, the clause, both parties shall keep this agreement, and everything contained herein shall form the sole agreement to govern the contract. Clearly stated that parties before this court chose to be bound by the clear terms of the contract, and that the clause portrayed the entire agreement in which the documents contain the totality of the parties' bargain. Your lordships, once a party has effected the signature on a contract agreement, usually they have agreed to everything contained in the contract agreement. Your lordships, in Leverage versus Ground Court Limited, citation provided for in the defendant brief of argument. affirmed that clause of any written contract are binding on signatories, even where a party is unaware of the contract's full content. Your Lordship, having inspected the building before the execution of the contract, the plaintiff also has raised the issue of ceiling reparation if he wasn't satisfied. Both parties thought. Yes, sir. Yes, Your Lordship.
Talked about the case of Lestrange and Grocott Limited, right?
Yes, Your Lordship.
Counsel.
Yes, Your Lordship.
I need the fact of that case. I want the fact of the next one.
In the case,
Lestrange and Grocott Limited.
In this case, yes. Lestrange contacted with Grocott over a material, and in the contract agreement, there was a clause stated in the contract agreement that Lestrange will have to pay some amount if what, Your Lordship, which Ms. Lestrange failed to read that part of the agreement. Eventually, when an issue occurred out of the contract, Ms. Leverage sued Grocott for this issue, and it was held that a clause of any written contract is binding on signature, even where the party has not read it. So the fact that Ms. Leverage did not read the clause does not mean she will not be bound by the clause, since it was stated clearly in the agreement.
How is that related to our present part? Counsel, I know you.
Yes, Your Lordship.
Oh, can't you hear me?
Yes, sir. I can hear you now.
How is all that related to the fact?
Okay, it is there in the clause that said both parties shall keep this agreement, and everything contained herein shall form the sole agreement to govern this contract. So it is related in fact that if a contract is in its written form, like the one Ben's PLC and Zen PLC signed, then parties are bound by everything, even if they have read or even if they have inspected the contract, what they contracted on.
Did the budget inspect anything?
It was not clearly stated that they inspected it. It was not clearly stated that it was not clearly stated in the statement of fact that they inspected the building. But before the execution of the contract, there must have been an inspection of the building. Because it's just like saying you want to purchase a phone. You will have checked the phone you want to purchase before actually purchasing the phone.
Good.
Your Lordship.
Good.
Okay. Counsel further argues that the principle of promissory estoppel shall further restrain the plaintiff from denying the fitness and suitability of the building, which he approved by conduct and agreed in the agreement. Yes, Your Lordship.
Counsel, stated in your advert that the building is a well-secured storehouse.
Yes, Your Lordship.
So how would you say that the destruction, the so-called destruction of the bank papers is as a result of your secured building?
Yes, Your Lordship. Come again, Your Lordship.
You stated in your advert that the building is a well-secured storehouse.
Yes.
So I'm stating that the plaintiffs claim that their banking items were destroyed, right?
Yes, Your Lordship.
So would you say that your building was secured enough for their documents, or were you luring them into a contract that would definitely not hold?
Your Lordship, we will state that our building was secured.
So it's the
destruction of their banking documents was as a result of act of God, event that was beyond our control. But still, yes, the building was well secured, which they totally agreed by signing the contract agreement. Your Lordship.
Yes, can you hear me?
Yes, I can hear you.
Okay, so answer my question. So how secured is your building for it to help in the security? Like
it was stated in the statement of fact, the building is well secured, which Ben's PLC totally agreed to by signing the contract agreement. The event that happened, the destruction of the banking document, was just and act of God. Is an event beyond our control. Such event could happen at any time, even if it was to Ben PLC that was using the building, Your Lordship.
Okay.
Counsel, sorry, say act of God. So, bad ceiling. They say
Your Lordship.
the building that needs it's not there. There's no enough security that you promised the other party. You are calling that an act of. Is that what you are saying?
But Your Lordship, the destruction of the banking document was not caused by the ceiling reparation.
I want you to explain what an act of God is, because you have this bad feelings, act of God, bad feelings. So
Well, I was just trying to say that the destruction of the banking document occurred. It can occur to anybody using the building, despite the fact that the building is well secured. The building is well secured, and this Benz PLC totally agreed to it, my lord.
Sorry, come again. I didn't get that. Come in.
The building is well secured, which Benz PLC totally agreed to in the statement of fact. The situation that happened can occur to anyone, even if it was Benz PLC that was using the apartment. That was what I meant by act of God.
But is that what act of God is?
No, act of God is the situation that occurred. I can hear you.
Explain to me what act of God is. What is act of God?
Act of God is a situation that occurred that is beyond the control of both parties, like caused by frustration. Like we can call, okay, if contracts are frustrated during this corona period time, it can be referred to as an act of God.
Go on.
Yes, Your Lordship. Thank you.
So what's the meaning of the implied term of fitness of purpose?
Your Lordship.
Yes, relate the concept of fitness of purpose to your argument. Did you hear my question?
The fitness of purpose is okay if you contract on a like Benz PLC contracted on this apartment, and the apartment was for storage purpose, which they totally signed the agreement, and they are even started using the building for storage. So that means the building was fit for the purpose for which they contracted on.
Okay, go on.
Your Lordship.
Yes, go on.
Can I proceed?
Yes, go on.
Okay. My lord, during the course of negotiation and inspection of the building, the plaintiff had made no comment on the state of the building. He expressed satisfaction and represented to the defendant that the building is fit and suitable for her use. Hence, he is held bound by such representation by conduct, and he cannot further be held to deny the representation that he gave that the building was okay. My lord, parties only executed the contract, and as such cannot be permitted to approbate or revoke it. And the court is not permitted to read into a contract a term that is not expressly agreed to.
Hold on a minute.
Okay.
I think you talked about promissory estoppel earlier on.
Yes.
Okay, what is the principle of promise?
The principle of promissory estoppel is where by conduct or by words a person express his satisfaction or intent about a particular thing, and he makes the other party to believe in such things, so that the party had contracted with him on the contract. So the principle of promissory estoppel is where by words or conduct one party to a transaction makes to the other party an unambiguous promise or assurance which is intended to affect the legal relation between them, whether or not the relationship is contractual, and the other party acts upon it, altering his position to his detriment. The party making the promise or assurance will not be permitted to act inconsistently with it. Your Lordship.
Okay, so don't you think that principle shoots you in the leg with that?
Yes, Your Lordship. Come again.
Okay, you agree with me that that is against your argument.
I can't hear you.
Counsel, can you hear me?
I can hear you now. Please, can you please talk louder?
Okay, sorry. Don't you think that school does not support your case in this particular thing?
I think it supported my case because, Your Lordship, it supported my case because before Ben's PLC would sign the contract agreement, before you would agree on anything, any particular thing you want to enter an agreement in, you must have a clear knowledge of what you are contracting on. Before Ben's PLC will sign the contract agreement, there must have been an inspection, even though it was not clearly stated in the statement of fact, of the building. You cannot just enter an agreement without knowing what you are agreeing on.
Hold on. But
yes,
you represented Ben's PLC that storage house secured. And she's the one that made the representation that made them come and enter into that company. Instead of now trying to turn it around.
Yes, we made the representation that the storage was well secured. And yes, the building is well secured. And they also represented to us that they agreed that the building is well secured.
Talking about your representation to them was that it was well secured. Meanwhile, it was not. So don't you think they acted based on that promise you made to them from the advert that it was to that point? I can barely hear you.
I don't think they acted based on the promise. They acted based on their satisfaction of the building. I said, well, I don't think they acted on the representation. They acted based on their satisfaction of the building, that the building is well and fit for their purpose.
Sorry, I can barely hear you.
I said, I don't think they had based on the representation. They acted based on their satisfaction that the building was fit and proper for their purpose.
For the purpose of it?
Yeah, it was fit and proper for the purpose because it was stated in the statement of fact that they had even started using the building before they even wrote to.
I'm not asking that. I'm saying based on the circumstances of the leaking roof and all the one of the faults that happened, is that building fit and proper for the purpose?
Yes, Your Lordship.
So a building that has a faulty ceiling, not in very good condition, after you made the representation that, oh, this secured building for you to do whatever you want to do, you are saying that building fit and proper. Counsel.
Fit and proper for the purpose for which? Yes, Your Lordship.
You are saying this kind of building is presently fit and proper, right?
Yes, Your Lordship.
Go on.
Your Lordship.
Yes, go on.
Your Lordship, parties duly executed the contract and as such cannot be permitted to approbate or reprobate the contract. The court is not permitted to read into the contract the term that is not expressly agreed to by both.
Counsel, your time is up.
By both parties.
Counsel, your time is up.
Okay.
The second line of my argument. I think the permission
will give you. Yes. I'll give you 2 minutes to wrap up. Go on.
I shall move to the second line of my argument, that the renovation of the building cannot be implied in the contract. My Lord, the principle of law is settled that a term can only be implied into a contract if the clause of the contract cannot be achieved or attained without such an implied term. In other words, a term is implied if the contract cannot work without such an implied term. My Lord, the plaintiff cannot successfully rely on the fact that it was an implied term for the building to be in order before they can move in finally, as the reparation of and renovation does not go to the root of the contract. My Lord, in Trolop and Coil Limited versus Northwest Regional Hospital Board, it was held that terms are only implied if the contract cannot work without it. My Lord, in this instant case, the primary essence of renting the building is for storing purpose, and Ben's PLC represented that the building is fit for such purpose during the course of negotiation. The plaintiff has even started using the building for storage of banking documents. Hence, my Lord, the contract is alive and workable, and an implied term is of no essence. Council finally adopts the prayer and submission provided in the Defendant brief of argument. If it pleases this court, my learned colleague shall proceed with issue 6.
So what's your prayer?
Pray that this court should enforce the clear terms of the contract, as Benz PLC has no duty in renovating the apartment, and you should favor Benz PLC in this case, Your Lordship.
Okay. Awujoola, I need you to look for this case for me before the end of this proceeding. UBA and Tejumola.
UBA and
Tejumola. Look for the facts and the holding for me. Yes.
UBA and what?
Tejumola.
Yes, Your Lordship. I'll do that.
Yes. Counsel for issue 6. Go on.
Justice Court. My Lord, I am Egunjobi Precious. I shall argue on issue 6 as to whether Zenzi PLC is liable in bailment. Counsel has 2 major submissions to make on this issue. 1. The contract between my client and Benz PLC is not a bailment and should not be handled as such. 2. The contract should be enforced based on the initial transactions between both parties. I hereby seek the relief of this court to move on with my argument.
Yes, go on.
Yes. It is pertinent to explain the term bailment. A bailment is the transfer of possession of goods from the owner, who is referred to as the bailor, to another person who is referred to as the bailee for a specific purpose and for a particular period of time. One of the major elements of a bailment is that a bailment deals majorly with chattels and personal properties, that is, movable goods. A bailment does not deal with immovable goods such as land and everything of value attached to it, such as foliage and permanent structures. My Lord, the only transaction between my client and Benz PLC is that of the lease of the Bongi House. My client leased out the Bongi House to the Benz PLC, thereby giving them possession of the house for the period stated in the agreement. From the agreement by both parties, it is clear that my client leased out the Bongi House, and there was no other agreement as to safeguarding the goods stored in the warehouse. The advert by my client was for the letting of the Bongi House as stated in paragraph 4 lines 2 to 3 and all of the statement of fact, and also in the documentary agreement. The agreement between both parties can only be classified a lease agreement. Relying on provisions of section 44 of the Equipment Leasing Act 2015, a lease agreement is a written agreement between a lessor and a lessee for the lessee's use in consideration of the payment of an agreed rental over a specified period. A lease guarantees the lessor payments for a specified period and guarantees the lessee usage of the assets. My client, although still the owner of the Bongi House, has given the control of the house to Benz PLC for the period of time stated in the agreement, and acceptance of the building by Benz PLC shows that they are pleased with the state of the building, including the security. The agreement has, however, saddled Benz PLC with the responsibility of maintaining and utilizing the house. Zenzi PLC is not a warehouser, but an agent for the Bongi House. The possession of the warehouse has been transferred to Benz PLC, and they are to perform the duty of a warehouser for their goods. To clarify the points made earlier, Counsel would like to refer this Honorable Court to the illuminating decision of the Court in Edwards versus West at Hospital Management Committee, where the Court held that a resident physician living in a staff hostel in the hospital cannot recover against the hospital, as the hospital owes no duty to the plaintiff to safeguard his property against theft. Moving to the second submission, my Lord, the underlying principle in law of contracts is that in any contract, the agreement of the parties at the point of making the contract shall be enforced in the court of law. The law is trite on a large number of authorities. The parties are bound by the conditions and terms of a contract they voluntarily entered into. A contract is bound by the original terms of the contract, and neither of the parties is allowed to seek better terms when the agreement is the subject of litigation. That once the terms of the contract are unambiguous and clear, it is the duty of the court to construe such contracts in line with the intentions of the contracting parties at the point of making the contract. Counsel relies on the decisions of the court in Olatunde versus Obafemi Awolowo University. My lord, information about the building was provided by my client in the advertisement, and acceptance by the appellant shows that they are pleased with the situation of things in the building. My lord, it was stated in the documentary agreement that both parties shall keep this agreement, and everything contained therein shall form the sole agreement to govern this contract. With the foregoing argument, my lord, counsel humbly submits and prays that this contract be governed by the agreements between both parties, and that my client is only bound by the lease agreement and should not be liable in bailment. I respond.
What do you want this court to do?
Okay, I want the court to treat the contract as a lease agreement and not as a bailment, and the contract to be governed by the initial agreement of the parties.
All right. Thank you. Yes. Adepetu PM. Egunjobi, mute your mic.
Yes, Your Honor.
Mute your mic.
Adepetu, can you hear me?
Yes, Your Honor.
Okay, I'm trying to look for your okay. Okay, I said you should read 4.1 of your brief. The provision and 4.2. Yes, read it.
Rule 9 sub 3 of the Rules of Professional Conduct for Legal Practitioners 2007. It states that a lawyer shall not sign documents, pleadings, affidavits, depositions, applications, instruments, agreements, letters, deeds, letters memorandum, reports, legal opinion, or similar documents, or process or file such documents as a legal practitioner, legal officer, or advisor of any governmental department or ministry or any corporation when he is in default of the payment of his annual practicing fee.
Yes, 4.2.
The provisions of this crystal clear rule disallows a legal practitioner who is in default of the payment of his annual practicing fee, no matter the reason, to appear before the court of law or even act in capacity of a legal practitioner.
So is there anywhere in that provision that it says you cannot appear in a court of law? A legal practitioner cannot appear in a court of law. I just want to fish out where it was stated in this provision. So you point me to the place so that we can go on.
You know, this provision provides for the things that a lawyer cannot do. And a lawyer cannot, if a lawyer appears in court of law, he must do one of these things, except he only serves as an audience to the case.
Okay. That'll be all for you.
Thank you.
Amoo, do you have any? Amoo, are you there?
I'm here. I don't have any question.
Okay. I believe we've come to the end of today's proceedings. We will take a 5 minutes. Okay. Do we have rebuttals?
Yes, Your Lordship.
Okay.
Yes, Your Lordships.
I'm not giving you extra time. We are doing your rebuttal now.
Your Lordship, the plaintiff will be rebutting on issue 4, 5, and 6. But first off, it's
Okay.
pertinent to bring you to know this for this honorable court that opposing counsel provided the cases of KD and Minister of FCT and Trolope and West Regional Hospital without citation. Your Lordships, in the case of Oni and Ekiti State, the court per OGJCA stated that where counsel cites a case that has not been reported, he owes the court a duty to produce a copy of the judgment if he wants the court to rely on such authority. Where copies of the judgment are not produced, the court will have nothing to rely upon. Also, Your Lordships, as regards to issue 4, they cited the wrong section in regards to the NBA Constitution that deals with the payment of fee. They cited section 3 sub 2, whereas the correct section is section 4 sub 1. Your Lordship also provided the quotation of NBA Chairman 2015 in a newspaper when they did not bring the newspaper to court. Such cannot bind the court. Your Lordship, moving on to issue 5, it seems like opposing counsel misconstrued facts as well as even law. Because in the case of Lestrand and F. Grocop that was relied upon by opposing counsel, the ratio behind that particular case was that the decision that the clause of a written contract is binding on the signatories is because of the presence of exclusion clauses. That is, when exclusion clauses are infused in a contract and the person signs such agreement, Your Lordship, irrespective of whether the person note of such exclusion clause, then it still binds the person, Your Lordship. It is one thing to know the law and another thing to properly apply it, Your Lordship. These facts are quite distinguishable. Also, Your Lordship, you cannot be a part of a judgment and leave out the other. Opposing counsel relied upon the case of KD Ventures and Honorable Minister FC, where they expressly stated that in that particular case, it was held that where terms and conditions of a contract are embodied in a written contract, the court will not be allowed to read into the extraneous term. Your Lordships, but a critical and full perusal of that case, relied upon by opposing counsel, would reveal that it was also held that in construction of a particular contract, any question as to the duration of contract is term or details that can be obtained, that such question can be obtained from express and implied term, Your Lordship, of the contract. And opposing counsel wanted to conceal the truth, Your Lordship, and did not bring that part of the judgment before this honorable court. Also, Your Lordships, in regards to issue 6, they compared trust to be the same as bailment, Your Lordship, whereas this bailment is distinct from trust. Trust is an arrangement whereby a person holds property as his nominal owner for the good of one or more beneficiaries. Bailment is simply the giving of possession temporary, Your Lordships. Possession keyword. This is for this honorable court, Your Lordships.
Yes, thank you very much.
Yes, Your Lordships.
Answer to the defendant. Are you there?
Yes, Your Honor, we have no rebuttal, Your Honor.
You have
Okay.
you have no rebuttal at all.
Yes, Your Honor, because we didn't hear what the counsel to the plaintiff said concerning issue 4. So we have no.
So you don't have any rebuttal concerning 5.
I can't hear you, Your Honor.
So
Yes,
you don't have
Your
any
Honor.
rebuttal concerning issue 5 or issue 6.
No, Your Honor, we don't.
Okay.
Awujoola P. I asked you to find a case for me. You have it. Okay, I think we'll get back to her.
Your Honor.
Yes. Do you
Can
have
I
it
proceed?
now? Yes, proceed.
Yes, Your Honor. In
Let's
UBA versus Tejumola, in the case, the appellant requested a list from the respondent. The request was, however, headed subject to contract. Consequently, there was an agreement between both parties. However, the appellant later withdrew from the agreement. The respondent then sued for a breach of contract. The respondent won in the High Court and the Court of Appeal. However, the Supreme Court overturned the judgment. The court held that the presence of the phrase subject to contract meant that subject to the drawing up of the former contract, the parties parties are still in negotiation state. However, Emeka Haguchiesi added that if all the basic terms of the contract have been agreed upon, the insertion of an ambiguous word was just mere cosmetic stoppage. That's the part of the case, my lord.
Thank you very much.
You're welcome. You're welcome.
So why did they put the subject to contract in the judgment, in the contract? Why was that phrase inserted in the contract? Did you read that part?
Read that part, yeah.
So go back, read it.
Okay, Your Honor. Oh.
Yes, go back and read it. Thank you very much for today's proceedings. We'll take 5 minutes recess to calculate and get back to you.
As the court pleases.
As the court pleases.
As the court pleases.
The court may rise for recess.